My name is Ben Rothermel. I've lived here for about 7 years, and when I first lived here, I worked for a intellectual property patent law firm in Northern Virginia. And after a few years, I was telecommuting, and after a few years, I realized that there was a need here for small businesses to have some legal expertise in intellectual property. So that would include patents, trademarks, copyrights, and I also do small business law. And really my goal is to be able to work with entrepreneurs. I noticed, working for a larger firm, that there's something sort of lost in the mix. You get some client relationships going, but really it's all about the business and not the person. And so I really enjoy working with actual people. And so I felt that I could match that need that I saw in the community with my enjoying working with people, and have really felt a lot of success just from a standpoint of personal satisfaction from my decision. So I'm really happy to be here in Winchester, and thanks for the opportunity, Christine.
Yeah, again, thanks for having us today. So what got me into law? The main areas I focus on are estate planning and business law. Heavier right now on estate planning, but they tend to go hand in hand. So one of the passions I have is small businesses. So all small businesses have issues as they grow, as they develop, as they expand. Essentially day to day, month to month, week to week, you're going to have issues that you're going to run into. So a lot of small businesses are 80% of small businesses are going to fail within 3 to 5 years. That's fact. If you look around, the statistics support that. So one of the value adds that I wanted to do with what I do is basically provide a means or support system or put something in place to essentially enable those businesses to get past those sticking points and get them past that 3-year mark, get them past that 5-year mark, to where hopefully the likelihood of success is going to be much greater than having not provided any kind of services to the small business owner. So I guess one of the things that got me into that, my undergraduate, believe it or not, is in health sciences. So I enjoyed helping people out with their lives back then. So it was like almost a natural transition to go into law. I actually helped set up the Hospital Wellness Center up in Martinsburg. This is back in 2001, right in that range there. So I was originally going to go into get my MBA, and I actually went about halfway through the MBA courses down at Shenandoah, and it was a very expensive mistake because I was like, I had an accounting class, and I'm like, I don't want to do this. There's no way I'm going to do this. So I ended up transitioning into law. So it was one of those things. I actually got into it with real estate, and then I just essentially it's evolved into dealing more with businesses, more with estates, and basically helping empower not only businesses but families to solve their own problems too.
Ben, we'll start with you. So the question is, my organization logo has not been trademarked. How important is it to trademark your company or organization logo, and how much does it cost?
So that's a good question, and that's right in the lane of what I do. I want to back it up just as sort of a preface and sort of try to put where I feel intellectual property protection and, for instance, trademark kind of falls into what a lot of people are doing as businesses. So you're trying to build value in your business, and some of that value is built through brick and mortar, being there in your shop and providing services or goods to your customers. Other parts of value in your company are what's called intangible, and that is the goodwill associated with your business or other types of maybe processes or ideas that you have that aren't necessarily on the forefront. It's not your storefront, but it's what creates a successful business. And so I try to match the goals of a business with what I do, which is protect sort of this behind the scenes or the intangible aspects of that. So trademark would be part of it. So when I talk about specific things like protecting a trademark, a logo, your company logo, that might not directly apply to you, but sort of the overarching theme is, how can I build value in my business besides just the services and goods that I provide every day? So trademark is an indicator of the source of goods or services that you provide. So you have this business and you have a name, and the customer associates that name with what you do. That is a trademark, and you want to protect that. And sometimes a logo or a name is protectable kind of inherently. So think about something like Xerox. It's sort of a fanciful name. It actually means something in Greek, I believe, but we don't speak Greek here, so it was protectable kind of inherently. Other things like, so say you call yourself, Shenandoah Valley Bakery, that's sort of descriptive of what you do and where you are. And that isn't as protectable, but all of them fall under the rubric of, here's a trademark. So a logo is important to trademark for a couple of reasons. One being that you want to try to create value in your company, like I said. Another thing is defensive. And what that means is you don't want to create a business and choose a name, or, for instance, become more publicly available with your company and have somebody else have a similar name as that, because that could incur some legal consequences to you. So it's, in my opinion, usually worth at least doing some due diligence about whether it's worth proceeding with protecting the logo. So that would include doing a trademark search. Sometimes you can do a trademark search yourself and you're like, hey, there's a logo out there that's just like this. That's something you're going to want to think about. Can I keep using this logo? Or do I want to protect it? Is someone else infringing mine? Typically, when you try to register a trademark federally, which means that's the R with the circle around it, that can cost a couple few $1,000s. It's very fact specific, and this is the disclaimer that Christine was talking about. Is this is not, everybody understands it. There's a factual inquiry that has to go on that a lawyer does. So there's no strict cost. Like if you go online and you're like, oh, this company says that they'll file a trademark for $300, you're really just getting what they provide. And my understanding is that there's very little flexibility in that. My goal is to develop a relationship, and my cost is typically higher than what's online, but I will work to get you the answer that you need. Not necessarily that you want, but it's what I will do, what I need to do to help you figure out what is the best way to proceed. So like I said, filing a trademark alone is usually about $1,000 to $2,000, depending on, there's some details about filing fees. So you have to pay the trademark office. And then on top of that, trademarks are examined, they're not just simply given to you. So then there's additional costs sometimes if you have to argue with the patent office, trademark office. Yes, sir.
But realistically speaking,
yes,
you have to be successful enough for you to start thinking about doing that.
It's a great point. So yes and no. Because so say your business is, you're saying, hey, look, I'm just going to be in Winchester. My name is, Shenandoah Valley Bakery. It may not be necessary to register your trademark federally, because the whole point of federal registration is to protect your mark nationwide. So if you're just going to be local, there's a thing called common law trademark, which is the TM symbol. And you don't have to have a registration for that. That adheres automatically upon your use of the mark in commerce. So if you were saying, hey, look, I'm just going to be local, you could slap a TM on your, even if it's something like Shenandoah Valley Bakery, which is very descriptive, you could put a TM on that, and that signals to other people, hey, don't use this name, don't use something similar to this, and you still have rights associated with that. So you can grow into needing to federally register your mark. And that's sort of what I advise people, because it's not cheap to do. But if you're thinking, hey, I'm going to expand my business, or maybe there's a risk, maybe you're a very publicly available business, like you have a big online presence, understanding, so there's two things. There's registration for the purposes of building value. And there's also like doing a search and understanding, is someone else going to come out of the woodwork and tell me you're infringing on my mark? So that due diligence aspect is worth investing in, even if you are a smaller business.
Okay.
So thank you for indulging me on that lengthy explanation. So I'll let you guys continue.
You kidding? That's your area. That's your area. And we're quite honestly, we're very thankful to have him here locally, because I know a lot of other business lawyers that we used to send business over the mountain because we didn't have a patent or trademark or intellectual property attorney here, and it's nice to have him here locally. So.
Kevin, this question's for you. Succession planning for my business seems expensive. How much does it cost to set up? Also, if I'm handing down the business to the next generation, do I need a trust or an estate? And what's the difference between personal and business succession planning?
It's more than one question. Soon. Well, first off, before I get into answering this question, just understand that what we're providing you here is hopefully a value for one, but it's just general information. As Ben was talking about, we can't really identify specifics with questions that are asked due to the fact that each individual circumstance is completely different than someone else's. So again, it's not legal advice, it's just general information. So that being said, let me tackle the first question. So succession planning, it can be expensive. It doesn't have to be expensive, because really when you're talking about succession planning, you're talking about someone's ability to take over your business should you not be there and be able to continue with the operations of your business. It could be, for example, let me give an example. For me, my basic succession plan right now is I have a deal worked out with another attorney in town. It's essentially a handshake deal, to where if I can't continue to operate, something happens, regardless of death, disability, whatever it is, then I have another attorney in town that's able to pick up my book of business and continue on with it. It's an agreement we have. And likewise with him, where if he has an issue, he can't continue on, it's a matter that I will be able to help him out with his clients and pick up where his clients are in their process of legal work. So it could be as simple as something as that. So something like that isn't expensive. So you're talking about just essentially a handshake deal to provide some value to you should you not be able to continue on with your business, whatever the circumstances. But yeah, it can get expensive. If you wanted something thoroughly worked out, if you wanted something to where, usually with an individual, you need to have some sort of an arrangement like that, to where you have someone that can possibly back you up. In fact, I just had a conversation with someone yesterday about this. Well, I don't have a succession plan. I'm like, well, do you know anyone else in your industry? Well, yeah, I do. Do you think they'd be able to help you out should you not be able to continue on with your clients, or if you're disabled or something like that? And he's like, yeah, probably. So I said, well, work out a deal with them. So it could be as simple as that. But if you wanted something to where, let's say you're a partnership or you have multiple partners in an LLC or corporation, whatever it is, then you may need something a little bit more formal in place. It could be something along the lines of an overall, I can put together an overall plan that will provide that if someone should either want out, because it could be just to the point to where someone says, I'm done, I don't want to do this anymore. You have to have a plan in place for that. You also have to have a plan in place for if someone passes away, someone dies. It could be funded by, and there's funding mechanisms for these different things too, because they could get very complex. What I'm saying is it's essentially a value ladder. So it could be anywhere from something very basic to something more complex. And that more complex, yeah, it's going to cost you money, because it's one of those things where it's not easy to put something like that together. It takes a lot of time. And essentially that's what we get billed for. We bill for time. We bill for the value that we can provide you with your business, and hopefully with, providing a solution for you. So again, the more complex the business is, the more you're going to have something that you really need that's concrete put in place. How is it going to be valued? Let's say one of the partners wants out, or one of the members of the LLC wants out. What's going to be the funding mechanism? If someone passed away, what's the funding mechanism there? And life insurance can oftentimes take care of a lot of these different things. So it could be very simple, very basic, depending on your needs. It could be very complex, depending, again, upon what your needs are. So hopefully I covered most of it can be expensive, and there's really, it all depends on what an individual's specific needs are for a succession plan, how much it's going to cost. The next question that was there is handing down a business to the next generation, do I need a trust or an estate? It could be done. I think that what you might have meant with the estate is maybe like a will, just a will. Because essentially with estate planning documents, you have the more advanced, complex estate planning documents such as your revocable trust, your pour-over will, power of attorney, medical directive, things like that. And then you have your basic one, which is essentially your will, power of attorney, medical directive. So the main documents when you pass away are going to be the trust versus the will. So you can actually account for your succession planning in both documents. You can essentially assign, you can basically say what happens to your business should you pass away. I want my business shares to go to whomever. But at the same time, you also may have to make sure that your foundational documents, your formation documents for your company, such as your, for example, your operating agreement for your LLC or your shareholder agreement for your corporation, they have to reflect the fact that your share is inheritable. Because if it's silent on that, then what happens, it's just going to end up being dissolved. You have to be very specific in your business formation documents as well as your estate planning documents, whether it be a trust or a will. They have to reflect one another. There has to be an agreement within the company, and there also has to be documentation within your personal estate plan too. So they have to reflect one another. Otherwise, what happens? It goes in front of the judge decides it, and chances are it's not going to get disposed of according to what you want. So the whole idea with planning documents, things like this, is that things get done according to what you want to do. It gives you the power back, because if you don't mention it, or if you have something that you just kind of cobbled together and you didn't take into all the different contingencies that you could possibly go through with your business, then what could happen is it's going to be left up to someone else to make that decision. And chances are that decision is not going to be what you want. So yeah, it's got to be reflected it can be reflected in both documents. Difference between a personal and business succession planning. I don't know how to answer that one. There's really no such thing as personal succession planning. Personal succession planning would be more along the lines of an estate plan. You're passing down to your heirs. I guess another way I can kind of, is someone here that asked that question? Can they kind of clarify that a little bit for me? No one wants to fess up to it, do they? Also, maybe if it was meant that it was a sole proprietorship, that would be more personal because it's taxed at the personal level that too. And I don't want to talk too much about taxes, but again, it's one of those things to make sure that you have it accurately reflected in your estate planning documentation, what happens to your business. As far as the business succession plan, so essentially that's, if whoever asked the question, if they're referring to a personal succession plan, that's going to be essentially taken care of by your estate planning documents. Business succession planning, that's something a little bit more formal, and it can be documented a little differently too. So hopefully I answered that question appropriately. So.
One of the things I was just going to jump in real quick is that because of our status, I guess, as lawyers that focus on small businesses, I think we try to understand the needs of small businesses, and we're not taking a shotgun approach where we're saying, you know what, we're going to maximize our billable hours, like we really kind of create this one-size-fits-all approach. We have the flexibility to create tailored approaches for your business, and I think I take pride in that, and I believe that Kevin does as well. And so he mentioned that we will figure out something that will work for you. I mean, obviously, if you come to us and you say, "Hey, I've got $100 to spend," you're not going to get much. But at the same time, I think that we create some flexibility in how we run our practice to accommodate different types of companies and different budgets.
Ben, this question's for you.
Excuse me.
I have the company name De Rouge Salon, and another salon in the area opened up as Cantina La Rouge. Can they do that?
That goes back to the disclaimer, is probably not going to delve into the specifics of that because it's a factual inquiry, and it's sort of weasel lawyer words to say that, but the analysis of trademark infringement is called likelihood of confusion. And so that's whether a member of the consuming public would be confused about the source of the goods or services. So there's different factors that go into this analysis. So for instance, is the channel of trade similar? So the businesses probably have a similar focus. So are people in that channel of trade, are consumers going to be sophisticated or not sophisticated? Are they going to be, not whether there's actual confusion, but would they likely be confused about who is providing those sources? There's also aspects having to do with the distinguishability of the name. So when you have words that are, like I said before, Shenandoah Valley Bakery is very descriptive of the services or goods that you provide. It's geographically descriptive, and it's descriptive of what you do, unless you were, maybe if you're providing, tech services, and you called yourself Shenandoah Valley Bakery, that would be more fanciful. And so what my point is it's harder to protect a name that's really descriptive of your goods or services. But, excuse me, if you build up goodwill in your business, so say you've been in business for 10 or 20 years, and someone comes in and they open up a business that's got a very similar name as yours, what that can create is you're saying, hey, you might be diluting this trademark, even though that it's not inherently protectable. And so those are sort of, it's a fact-based inquiry. And so what you have to look at is, what do you need to do to enforce your mark? Do you really feel like someone creating a business with a similar name as yours is actually decreasing the value of your business? And that is a different story. If you say, hey, it really is, then you do have to think about ways to mitigate that. Now, if you just go whole hog and you just straight up sue them, you do need to be very careful about the factual merits of your case. But if you feel like, hey, this is impacting the value of my business, especially in a small community like this, you might consider approaching them or figuring out a way to negotiate some type of arrangement with them that it falls short of litigation, because the analysis that goes into litigation is going to be, you don't want to invest that time and money if you're not going to be at least reasonably successful, unless you can, there's a strategy aspect to it too. It's if you know that you've got a lot of resources and they don't have a lot of resources, you can make it more difficult for them to conduct business if you're really kind of breathing down their throat from a legal standpoint. So, from a standpoint of, hey, is this infringement? I think it's hard to say unless someone just straight takes your business name that there is infringement. And so you have to be very careful about the analysis, especially prior to making some bold statements.
Thank you, Kevin.
Mm-hmm.
This question's for you. What are the options for different types of partnerships? And can you share an example of where a business has a 50-50 partnership but distributes profits differently?
I have to unpack this one a little bit. When you talk about partnerships, is the person here that asked this one? Yes. Okay, good. Are you referring to partnerships straight line, common law partnerships, or are you talking about maybe like LLCs or partnerships where two people set up and form a business together?
Yeah, it needs to be formalized. It's already an LLC as a sole proprietorship, and I'm considering turning it into a partnership.
Excellent. Okay. So are you talking about straight up partnership? So you're talking about an LLC then, as far as setting up a business to do an LLC and then teaming up with someone about it, or are you talking about strict line partnership where you basically just have an agreement between the two of you?
Well, that's part of my question.
Okay,
what
good.
are the options?
Gotcha. Okay, that's good then. It's rare when people form partnerships anymore. The straight line partnerships, for one, the agreements are often very expensive for straight line partnerships, just for the mere fact there are a lot of different nuances that are not covered essentially under like the Virginia Limited Liability Act or the Corporation Act, things like that. So it's not defined by code; it's essentially defined by agreement. So when you're setting up a partnership, there's a lot of different things to look at when it comes to how profits are going to be taken. Going to succession planning, what happens if one of the partners passes away? Who's responsible for what? So there's a lot of different descriptions that you have to put into a straight line partnership agreement. I'm not a huge fan of that, just for the mere fact of what I look at when I help people set up businesses is the limitation of liability. And that's a big part of it, because if you get sued, and the whole thing is things are great when they're running well, but then, if a lawsuit happens, you want to look to maximize your different protections. And there are more formal structures in place, such as your limited liability company, such as your S corporation, your C corporation, things like that, to where it'll provide you with that necessary protection, as long as you're running it right, disclaimer there, to where if someone were to sue you, they're not going to come after your personal assets. And that's the whole thing. You want to try to separate yourself from your business as much as possible to limit your risk. Now, as far as does that answer your question a little bit about that? I want to talk about the breakdown of 50-50 too.
example, right now I'm trying to decide, and usually people advise against partnerships for all the obvious reasons, because mostly they don't work, and I've seen that personally. But yeah, so that's part of my question is, what would you advise? Is there a separate agreement that would still limit liability for both people? So in other words, if I kept it as a sole proprietorship, but had a contractual agreement with how we split our profits, that would then not protect him. Is that correct? So in other
What
words,
would protect him?
if I own the company as an LLC and I have that limited liability, he would not if he's not listed as a partner.
That's correct. Well, he would be, I mean, if you're talking about like setting him up to where he'd be a contractor, then there would be just another agreement that would essentially establish that relationship between the LLC and the other individual. So there are a lot of different ways to work something like this. And again, it all goes back to limiting your liability to where if you're going to get sued. But as far as, breaking down who gets what as far as profit goes from the company, there are ways to do that with just an LLC too. I mean, you just have to make sure that your operating agreement is crafted properly to where you're going to outline the fact that I'm essentially bringing this capital into this business, and you could be bringing a larger amount of capital, assets, and so forth into the business, and this person's not. So it could be reflected in the breakdown. You could still make it 50-50 as far as ownership interest goes, but at the same time, you have to be very careful on how you craft that operating agreement. This is something that should be done in conjunction with a CPA as well, because there's certain provisions that you can put into an operating agreement, which is called special allocation clauses, to where you can actually take out different value when you're paid, and you take out a draw, you take out not 50-50. So there are a lot of different ways to work, and it would really all depend on, and what's nice is, again, it goes back to really there's no blanket solution to any one particular question. It would be a matter of sitting down and really trying to peel back to identify what you want to do, how you want to structure it, what that relationship is going to look like, what's going to look like in 5 years from now, what's going to look like in 10 years from now. Because these things can kind of evolve over time as well. You can update certain documents, and it would provide you with the necessary means to get to that end goal, whatever that may be. So do you have any other questions based on that? Did I answer that enough for you?
Yeah, it helped.
Yeah, I mean, and you can, like I said, you can go straight line partnership too, and just make sure you outline things properly in your agreement to where you're going to say, well, it all depends on what you want the partnership to look like. And you just have to be very specific, because usually, and here's the thing, usually when you get going into a business, things are great. I mean, people riding high, it's really good. Emotions are high. You want to go out there and you want to take on the world. Then all of a sudden what happens is you don't account for, we'll get to that agreement later, but we're just running our business right now. That's a time you want to get a good agreement into place, because, man, I'll tell you what, 3 years, 5 years from now, if you don't think any disputes are going to arise, it happens. It happens a lot. A lot of partnerships break up. So you want to make sure that you have the proper document in place, again, to where what happens if this happens? What's decision-making authority? If someone wants out or if there's a dispute, how's it get resolved? And when it's 50-50, you got to watch about that too, because you're talking about equal decision-making authority. How are ties broken? If you guys don't agree on something, you got to have a solution in place in order to get past that point. Who's going to be your arbitrator? You have to kind of think through these different things. So,
question similar to hers. Next year, I'm planning on open a clothing online store with my mother. So I trust her. We trust each other. But what would your recommendation be for in order for me to register the company? How should I register? A partnership, something?
Again, it all goes back to what your goals are. I mean, I'm not a huge fan of straight line partnerships, again, because you're going to have personal liability if you have a straight line partnership. If you get sued, they're coming after you personally. You're coming after your personal assets. The whole reason that you put a structure into place such as your S Corp or your limited liability company is to essentially insulate your personal selves from the business. Because if the business is sued, the hope is they don't come after you personally. As long as you've been running your business properly, the likelihood of them being able to go after your business or after you personally is very limited.
Okay. So, what is your recommendation? What should I register as?
What should you say again?
Clothing store, but how should I register that?
This gets into personal advice. You need to, once you're ready to move forward with it, you need to sit down with someone to identify what's going to be your. And again, it's going to be a series of questions. And it's going to be a lot more time than we're going to have today. So I highly recommend reach out to one of us and we can kind of walk you through the process a little bit. Okay?
Gotcha.
While you're there, could you define an LLC, a C Corp, and an S Corp for us?
Sure. LLC is a very simple structure. The most formal types of businesses, or the most formal type of business, is going to be your corporation. And usually, when you register as a corporation, you're going to automatically be a C Corp. C Corp. All these different structures are going to protect you from personal liability should you organize them properly. But there's going to be, the whole thing is the taxation of that particular entity is going to be the real main crux of how big's your company, how big is it going to grow, how do you want to set up initially, where are you going to be from 5 years from now. So the corporation has a very formalized structure, and it's going to be taxed at 2 different levels, 2 different tiers. S Corp is still going to be just taxed at 1 tier. LLC is going to be taxed at your individual levels. So if it's a multi-member LLC, it's going to be, you're going to have typically 2 tax returns. It's going to be a partnership tax return. You get a Schedule K from that. You'll be reported on your personal income taxes. If it's a single member LLC, then that's what's considered a disregarded entity. So you're going to be taxed at the personal level for something like that. But again, I'm talking about, there are 2 separate issues you look at when you're setting up an organization. You're talking about the tax level, and you're also talking about the personal liability level. I look at the personal liability level, and hopefully the individual has given some thought a little bit about what they want to do as far as tax-wise goes. But it's also one of those things where I don't give tax advice. I know enough to be generally knowledgeable about just a different subject matter, but at the same time, a business needs to make sure that they have a decent CPA as well.
Thank you, Ken. Ben, I think I have something that is patentable. Should I hold the patent as an individual, as my company, or as my nonprofit entity?
Sure. The 2 issues that I see are that you want to break. It's similar, sort of, to what Kevin's talking about. Is there's a lot of what I focus on is risk mitigation, and when you come into questions about patentability, you want to put the risk. You want to take the risk away from you personally, generally speaking, because you don't want your personal assets. I mean, that's sort of a baseline consideration I think that both Kevin and I have when you're working with a business. I mean, part of the whole structure in the 21st century, I mean, this started with when they created the LLC entity back in the late 80s or whatever, was to try to make it easier for individuals to invest in businesses by allowing liability to be taken off of their shoulders personally. So if you're properly structuring an entity, that the liability, if somebody sues you, is only going to fall onto that entity, not your personal assets. So that encourages people to invest in businesses. So I look at, especially in this sphere of sort of the local economy and small businesses and entrepreneurs, is trying to figure out ways to shift risk. So the entity that you probably want a patent held in is probably your business from the standpoint of avoiding risk, especially if that entity intends on practicing in the sphere of industry where you're developing that technology. Because if you're hit for something like infringement allegation, you don't want those allegations coming against you personally. Similarly, if you have an entity like an LLC or a corporation that holds that patent, then you can also build values, like what I was talking about before. You're building intangible value in your business. And so say you're saying, well, you know what, I'm not going to be practicing this. I'm really just going to get this patent and I'm going to sell the company. That is how you would do that. You know, there's other ways. I mean, if you held it individually, you could sell the patent or you could license it. There's no bar against that. But I find that many people want to build value into a business that they're creating. The flip side of that is if you have a business where, say, you have, say you're the sole inventor, but your business is held by multiple people, and you don't want the proceeds of that patent or the control over that patent to be manifested by multiple people, you have to be careful about who owns it. So if you created something while working for a company and you have an agreement, I have to assign this invention to my company, you may not have a choice that it's going to be owned by the company. But if you're, say, oh goodness, say you come up with an invention and you say, well, you know what, this is going to cost thousands of dollars for me to get this patent. I need to create a company. I need to bring in a business partner. That business partner may, like Kevin was saying, when you create an LLC or whatever, you have different ownership structures. That person may have control over how the patent application is actually handled. Not necessarily that they can unilaterally take any action, but it might be easier for you as an individual to hold on to that while it's being patented. So it's a very fact-specific question. I don't think that there's an answer like, hey, I should just put this in my company and roll with it. But there's some strategy that goes in there, because you might be leveraging that patent application to attract investment. And so you want to make sure that you're kind of choosing the right route. There's not necessarily one right way of doing it.
Thank you, Ben.
Yeah, sure.
Kevin, I see other businesses using shady advertising to attack other businesses. How do they get away with it? What is the line not to cross? And how far can I go without being sued? This was not my personal question, by the way.
Let me just kind of start off by saying I'm not a libel or slander expert by any stretch of the imagination. So if someone were to come into me and ask, well, I have someone kind of personally attacking me. I mean, when I first went out on my own, there were murmurings. I could tell there were certain people that probably weren't happy with that when I first went out on my own. But I guess my question back would be, do you really want to stoop to the level and just start creating a war of words? Because when you start that battle, there's no end. It will keep going and keep going and keep going. I actually advise people all the time on this. Whether it's be an organization where someone's breaking off and setting out on their own, that's usually when it happens. It's going to happen quite a bit. It happens all the time. It happened to me a little bit. It's going to happen I just met with someone yesterday where we were trying to figure out, hypothetically going through different scenarios. I'm like, your people are going to come after you. They're going to say bad things about you. I'd say, for one, callous it a little bit. You're going to get calloused about this, because they're typically going to look at someone as a direct threat upon their business and their well-being, and that's usually when the barbs come out. They usually try to come after someone, whether it be on Facebook, and anymore on Facebook. I mean, social media is both a blessing and a curse at the same time, because you can say anything you want to on there and really not have any factual basis to back that up. As far as, I would definitely advise someone to take the high road when it comes to if someone's personally attacking them and saying, well, this business does this or this business does that. There's really no bright line when it comes to what's going to constitute an actual offense. It's a matter of, if someone's going to call them out or not, because essentially they'll get away with it as long as the person doesn't call them out on it and do a lawsuit for libel or slander. So it's gonna vary. I definitely say take the high road with something like that, because that person's gonna look really bad in the long run when it comes to if they're trying to badmouth your business. Things will work out. If you have a decent reputation in town, we're Winchester. People know if someone's got a good reputation or bad reputation. They'll know.
Now that was my question, and the word shady kind of made it look bad, but. One of the classes that I took at Old Fairfax was marketing, and I felt that I was really good at marketing. I'm a very creative person. And by going through the classes, I realized that some marketing strategies were so much better than others. The best ones are the ones that are almost to the point of mocking another company, without actually calling the name. For example, Pepsi would use a Coca-Cola can in one of the commercials to say that, don't drink this, or another Burger King would use don't buy frozen something and so on. So I see they play this game, and it's very successful because people talk about it. So let me give you a very quick example for what I want to do. I'm currently working on a restaurant that I want to do, and I want it to be very popular. So I'm working on tacos. So I want to be able to use some references against Chick-fil-A. And I'll tell you what really quick, once again, I'm not taking too long. I have a dog, it's a puppy, and it looks like a cow. So I want to be able to use this character and kind of mimic the don't eat more chicken, instead of that I want to say eat more tacos, whatever. So it's very similar to Chick-fil-A's advertising. So I want to get close, but I don't want to get to the point of, okay, you're already going too far with copying the way they advertise. So I want to know that how far I can get before I'm like, okay, don't cross that line.
I'm sure there's infringements that
Yeah,
you may want to get into
that's
on
some
this.
copyright.
But understand
Push.
something new too at the same time. I'm going to let Ben address the whole copywriting infringement and things like that. But when you essentially advertise by pulling another company in, you're also drawing attention to that other company too. So it could actually backfire on you at the same time. So it's one of those things that you want to play very carefully. But yeah, I mean, I think I'm trying to think. I do a lot of reading, a lot of podcast listening. I think there's an example where I think what it was McDonald's and Burger King. They were having kind of a battle back and forth at one point, and it was Burger King to place the ad out, say, hey, go to McDonald's, and when you're at McDonald's, they geocoded it to where when you're there, you got a coupon for a Whopper. It was cool. It was kind of cool, and their sales went up as a result of it. So you have to be careful not to, maybe ingest things like that. But I'm going to let Ben address the whole copyright infringement thing.
That's a great point. I mean, so copyright, there are some aspects of parody and fair use. Can you do that? But the issue becomes then is that it's actually not just copyright, but trademark dilution and basically unfair competition, where you're using someone else's trademark, right, to increase your business. So you're not just parodying it, you're essentially potentially copying it, trading on the goodwill of Chick-fil-A. Now, I don't know how similar the advertisement is. For instance, like, is it going to be sort of like you said, maybe like a dog dressed up like a cow? And I can't remember exactly what the Chick-fil-A commercial is, but there's that element. And then there's also, copyright infringement is based on the concept of substantial similarity. So it's not that you would need to necessarily copy something exactly for there to be potential copyright infringement. And what you end up getting to is there's this gray area, right? And how likely is it that Chick-fil-A is going to come after you? And so there's a business aspect to that. I as a lawyer would never recommend that you do something that I felt like was likely to be considered infringement, but there is ultimately a business decision. If you're like, look, I'm really going to be doing this, who knows? Locally, I don't think, you might not think that there's a likelihood of infringement. I mean, it's not like, if you commit infringement, it's generally not a crime. I mean, there are some types of infringement that are criminal, that have criminal penalties, but ultimately the risk that you run is that you get a cease and desist letter, you might get sued, and that's not something for a small business that I really ever recommend. I say, you probably ought to take a step back and worry about, focusing on growing your business, not can I do this and cut the line really close and maybe not get sued. That's sort of how I look at things. But, artists, you have to sometimes push the envelope to feel like you're accessing your inner, the reason why you're running your business. And that's a business decision. I can only say, hey, here's this risk. Chick-fil-A is known to go and sue people for copyright infringement or trademark infringement, and so your risk is really high, or something like that.
Thank you.
Yeah, sure.
That's good.
So Ben, what are the things you see small businesses get into trouble for the most? What do they get sued for the most?
I think for these questions, these are good. Like, it seems like there's some overlap between Kevin's sphere and mine. So I'm not going to fully defer to him, but I probably would say that not having adequate contracts, that really, I'm in the business of mitigating risk. And so when you memorialize your business, whether it's something mundane, like a contract for the sale of your goods or a service contract, up to something very specific like your succession planning for your business, memorializing those crucial aspects of your business in writing is really important, because you're going to get down on paper how you think things should be run. And especially if it's requiring you to interact with other people, whether or not they're in your organization or outside of your organization, failing to adequately memorialize that and record the mutual understanding of the involved parties, I think creates a big risk. Would you have anything to add to that?
No, I completely agree. Making sure you have adequate contracts, because like I said, when business relationships are good, they're good. What you're trying to prevent is if that business relationship goes south, or that business to customer relationship goes south. You want to basically have a solid document in place to where if a judge has to decide a case, they can point to the contract and say, no, you're right, you're wrong, it's in here, it says exactly this. If there's gray, then that's going to be a point of contention, and it's also a litigious matter where the judge is going to decide who's telling the truth, what's right, what's wrong.
And your costs are going to go up.
Your costs go way up, exactly. I mean,
so that's a big factor too,
Yes.
is that, an ounce of cure is worth a pound of prevention. No, whatever, vice versa.
Yeah, totally.
But it's sort of like, you might say, hey, and this is really expensive to pay a lawyer to review this contract. Can't I just kind of get by with a handshake agreement? If you go to litigation, you're going to be looking at 10 times that cost minimum. And then you're going to have to be dealing with lawyers all the time, not just...
And their bills. And their bills.
Cynthia, can I ask that, as simple as a purchase order is a contract between you and your customer or vendor, and it's vital to a small business. I watched a small business locally take a big order from a large corporation, somewhat local, trusted that verbal order was going to hold up. They went and bought all of the goods they needed to produce, and then the company pulled the order. And there they sat with all of this production in place and no risk. So it's really important to get it in writing. They had nothing to stand on but a conversation from someone they trusted.
It's a fantastic point. I mean, oral contracts are valid in Virginia. They're valid for, I think, was it 4 years? 4 years? 3, 4 years?
Yeah.
Something like that. But the problem is when you don't have anything in place, you just have an oral contract in place. You can bring that to court, but what happens is you don't have anything written down. So the judge has to try to, or the juror, hopefully it's not a jury, but they have to try to unpack what the terms of this agreement are. And what's the way they find out about it? They find out about it through testimony. You're talking about a drawn-out process to identify what the contract terms are. That's essentially oral. And if you think that I'm going to say something and that other person's not going to agree, then again, it's a long, drawn-out process. You throw lawyers into the mix, it gets very expensive very quickly.
Melissa?
To that end, what about emails serving as documentation of mutual understanding, or not to take the place of having a contract, but to substantiate, here's what we agreed to?
It helps.
Okay.
It helps.
Will an email hold up in court, or do you have to have a contract?
Well, I mean, an email will possibly hold up if it's an oral contract and they're trying to identify the different terms of the contract. But if people are signing a contract, oftentimes there are going to be disclosures in that contract or terms in that contract that say any change to this contract needs to be in writing and signed by both parties. An email will not suffice on something like that.
Okay. That's good to know. Thank you.
Yep.
Thank you. Kevin, what are the legal requirements to have a business in Virginia?
It helps.
Will an email hold up in court, or do you have to have a contract?
Well, I mean, an email will possibly hold up if it's an oral contract and they're trying to identify the different terms of the contract. But if people are signing a contract, oftentimes there are going to be disclosures in that contract or terms in that contract that say any change to this contract needs to be in writing and signed by both parties. An email will not suffice on something like that.
Okay. That's good to know. Thank you.
Yep.
Thank you. Kevin, what are the legal requirements to have a business in Virginia?
I have a business. I open up a bank account. You could be sole proprietor and really not. sole proprietor is a very informal structure for a business. You could basically just say, hey, today I have a business. I'm going to name it this. And essentially all you'd have to do is just have your name, DBA, and whatever business name you want. File at the courthouse, get it back, file it with the state. So it's very easy to set up a business in Virginia. So to set up a formal business in Virginia, you have to do, there are many other things you have to do. You have to register with the state, you have to make sure you have the proper documentation in place, EIN, I mean, the list goes on. So, but to set up just a very basic sole proprietor business in Virginia, it's very easy. You just basically say, I'm in business, you open up a bank account, and don't commingle funds. So, yeah.
So I should have clarified. You and I have talked a little bit about this, and so I'm an LLC, so there's a lot more. If I were to, I'm in West Virginia, if I were to establish in Virginia, there was a lot more documentation that I wasn't aware of, and so if you can expand on that.
Absolutely, absolutely. Yeah. So if you're a foreign LLC, if you've founded your LLC in another state, West Virginia, Tennessee, wherever, then you could basically set up as what's called a foreign LLC in Virginia. So you would have to register with the state. It's documentation you fill out, file with the state, nominal fee, and now you're established as a business within the Commonwealth of Virginia, or able to do business in the Commonwealth of Virginia. You have to have registered agent that's going to be in the Commonwealth of Virginia, and you have to have a principal place of business in the Commonwealth of Virginia. So as far as that goes and being able to do business in Virginia, now you're set up to do business in Virginia. If you wanted to move your business from another state to Virginia, then what you're going to do at that point, that's called domestication of your LLC for Virginia. Again, you would almost have to set up the new business. You're going to have to set up another business in Virginia and dissolve the one in another state or Commonwealth, and in order to basically establish your business then in Virginia. So, does that answer it?
There was like a really long contract that would be if I were domesticated.
Yeah, it's that form from the State Corporation Commission. So there's a form you fill out, and you basically file articles of foreign entity. I forget what's termed as, but it's really a matter of just filing that, and making sure that you have the contacts that you need in that particular state in order to do business.
Ben, how can a lawyer help my business?
I think this is something that we've sort of been covering kind of in general today, is that a lawyer is part of a team that you hopefully are creating or thinking about creating to serve your business. I'm a strong believer in having a team of people that helps me think about how I run my business. Kevin, I would consider to be on that team. It can be formal or it can be informal. The Small Business Development Center, they're instrumental. I always refer people to that, and they're not lawyers, but what they do is they create a sort of a critical mass of brain power that can help your business flourish. I really value my role as a counselor to entities very highly. That's one of the reasons why I went into business for myself, is because I felt like I could offer that sort of strategy aspect versus just achieving. Yes, a lawyer can achieve a discrete function. If you come in and say, hey, I want you to file this trademark, bing, bang, boom, thank you very much, I can do that. But I think that especially a small business, is going to get a lot more out of what they pay for a lawyer if they treat them as a strategic partner. Mm-hmm. Kevin?
No, I agree. It's a matter of having a proper network in place to where if you have the issues, if you want to get things done, it's very difficult to grow a business and be prosperous at a business on your own. You have to make sure you surround yourself with an appropriate network of people to where you can get things done. If you have a hang-up, you have an issue that comes up, to be able to overcome those issues and have the proper network in place to get you past those issues. So I agree, absolutely.
Good.
I think the next two questions will combine, because again, we've kind of been talking about this all along, and then we'll open it up to anyone else for questions. But the next two questions are, what can I do to protect my business from lawsuits, and what contracts should I have in place? So they kind of go together. Would both of you like to expand on that?
Okay.
Yeah, I can start. The key aspects of your business, and we sort of went over this before. So thinking about what is it that I do that's critical to my business. So there's going to be some things, like getting internet, you have to sign a contract with Comcast or whomever. But some things you might not need to, like the purchase order that you were talking about, Cynthia. You think you might be able to get by with a handshake. So understanding what those key elements of your business are and putting those in writing. And then also figuring out what key elements of the business are that aren't necessarily how the business functions on a day-to-day basis, but sort of the background things like an operating agreement. Things that I would focus on from the intellectual property standpoint would be things like non-disclosure agreements saying, hey, I'm going to talk to this potential vendor about my invention. I need to make sure that there's some protection in place. And having that understanding, it goes back to having a mutual understanding between the parties. If a vendor sees, hey, you know what, they've got this NDA, they might think twice about infringing or not stealing your idea, but potentially infringing. And likewise, if you go to somebody and you're like, hey, we should memorialize this in writing, and they say, well, why do we need a written contract? Maybe you should think about, do I really want to be doing business with this person? I mean, that's fairly common for people to say, hey, we're gentlemen here, we can just do a handshake agreement. Is that the type of business you want to run? I don't advise that, but it is one way to do business.
Yeah, going to the question, what can I do to protect my business from lawsuits? I mean, anytime you're making an agreement with a customer, a vendor, another business, provider, it doesn't matter. I mean, you want to make sure that the appropriate contract is in place. So, I mean, there are certain things that you can do to essentially try to prevent any kind of lawsuit from happening. Nothing is going to be foolproof. I mean, we live in a society to where, things get done. A lot of times they sue people. If they feel they're wrong, they sue people. So you want to make sure you have the proper contracts in place to where if you do get sued, the judge can easily define, okay, what you're saying is right, what you're saying is wrong, and essentially look to the terms of the agreement to decide a case. But nothing is going to prevent you from actually getting sued. And you shouldn't operate your business with the fear of getting sued, because it's going to prevent you, and it might prevent you from taking that little bit of risk that you need to take in order to grow your organization too. So it's kind of a catch-22. I mean, you definitely want to make sure that the proper documents are in place. As far as like the specific documents, it all depends on what your business is. I mean, if someone's an online provider, they're gonna have different contracts in place than someone is product based or service based. So it's going to vary between the different organizations. So I mean, no two cases that we probably deal with are completely alike. So it's one of those things where you just slowly chip away at what you need to get in place. Because I mean, if you try to do everything all at once, yeah, it can be expensive, but you need to prioritize, okay, well, first I need this, first I need that, and get the different things in place. But nothing's going to completely prevent you from getting sued. And if when you get the hiccups in the economy to where you have a decline in the economy, you're going to see more lawsuits because people want to try to get the money.
And there's, like you said, is you do want to chip away at it, identifying the key things that need to be in writing. And there's ways to mitigate your costs too. I don't recommend just taking a form off the internet and using it. But there are ways to reduce the cost. You don't have to have a lawyer draft a contract from whole cloth if it's a standard purchase order agreement. I mean, there's ways to make it fit within your budget. I think the key thing is identifying what the key elements of your business are that need to be recorded and finding a way to get that down. And that I do recommend working with a lawyer to do that. I have seen a lot of it, especially having to do with more complex things like non-disclosure agreements and say like an inventor wants to work with a prototype manufacturer. They'll come to me and they'll say, oh, I entered into this agreement, here's this contract, and there's some provisions in there. Like if you're working with a larger entity especially, they might have their own form contracts, but they're going to be very one-sided. And they may not do business with you if you want to negotiate it, but you have to at least be aware of that to say, hey, this is a contract that doesn't favor me. They will not allow me to modify it. But you're not going to necessarily know that unless you, for instance, say, hey, I need to go talk about this with my lawyer. And I might point out, hey, this says if you leave them that you have to assign your invention to them. You might not want that provision in there. you know, you can usually overcome the major issues by at least going and referring to a lawyer to discuss a form, something like that.
Absolutely. I can't tell you the number of times I've had someone come in and meet with me, and they'll say, hey, I have this contract that I've been dealing with this vendor, and they're telling me I have to do this, but I was told originally I wasn't going to have to do that. So you're basically coming to me after the fact, and a lot of times what happens is I look at them and I say, nope, what they're telling you is exactly right. So it's a nominal fee, which you'd have to probably pay an attorney to have them review a contract and give you the ins and outs, saying, hey, here's a red flag here, just to make you aware of this, and to be knowledgeable about it, to where if something does happen, you know what to expect. Because again, it all comes down to, you know, if you don't do your proper diligence, I'm not trying to scare the hell out of people, if you don't do your proper diligence and a lawsuit happens, that has the ability, if you're a small business, that has the ability to shut you down. So you want to try to do everything you possibly can. I mean, if it requires just a nominal contract review, get that review to where you know what to expect. Because last thing you want is to get that lawsuit and have them, you can't pay it. You can't pay it. So it's all about getting you past these sticking points to make you hopefully a successful business.
Thank you. So at this time, we're going to open it up to questions from you all. What other questions do you have?
Good question. And I think everybody would like to know, and I don't know if this video is going to be uploaded or not, but I'm sure people would want to know. What's the cost to have a session with an attorney or lawyer that we're having right here? What should we expect as cost?
Well, the way that I do my business is that I'm happy to have a short free consultation. So what we're talking about now, I mean, we probably would cover one, maybe two of these points. Say if you called me or set up a phone call, I can't give substantive advice in that initial consultation. I do a hour-long consultation. For me, it's $250. That's my, you know, that's sort of a, and then going from there, you know, a lot of the times the things that I'm dealing with are sufficiently complex. I can't even really scratch the surface in that hour consultation. I'm happy if that's someone's budget. I'm happy to do what I can in that hour. A lot of times what I try to do is within the rubric of a free consultation, kind of give them some options and some rough cost estimates, so that way they can decide whether or not they can move forward with working with me. Like I said, I try very hard to make something work for everybody's budget as long as it's somewhat reasonable, and then kind of go from there.
Yeah, I agree. It's the same with me. I oftentimes offer a half-hour, 45-minute consultation just to kind of try to unpack the issues for you a little bit, to identify like what you need to do for your business, where you need to go, and then kind of give you some estimates of what the cost is going to be behind it.
I have questions, one that you both may want to address and one specifically for you, Ben.
Mm-hmm.
The first is with regard to insurance and business structures. So with an LLC, in addition to having your general liability for the business, do you have any recommendations for, you know, taking an umbrella policy to protect you personally should someone try to come after you personally? Do you feel that that's advantageous, not necessary?
Can I take it?
Yeah, yeah.
Okay. Yeah, general liability, definitely sit down. Again, an insurance professional, that's going to be someone that's going to be a part of your key network
Yes.
as well, without a doubt. So they're going to have possible recommendations of what you may want to do, what you may not want to do based on your individual profession. Lawyers, we have different pockets of insurance that we have to have in place. Different professions will have different protections they need to have in place.
Mm-hmm.
I'm actually I'm a fan of having that umbrella policy. I have one. Just again, if they try to come after me personally, so
Right.
at least I have something in place to where it wouldn't like completely shut me down to where I have to declare bankruptcy or anything like that. So I'm a fan, but there are other ways where I've actually gotten quotes from other agents that I may end up switching to. I don't know.
Okay.
That where I don't need something like that in place, where they have some other different things built into an individual or not an individual policy, but a business policy.
Okay,
Mm-hmm.
thank you. Ben, my question's for you. The initial question was about trademarking the design mark, correct?
Oh, yeah.
Which I do have for one of my businesses.
Okay.
So this is a two-part question.
Sure.
Do you recommend also registering the business name?
Yeah, so that's something that is a very common consideration, right? So what's called a word mark for a trademark is actually a broader way to protect your business name if you register it, because a word mark can be something that you can write in any font, any color. You could have it written down in a piece of paper or whatever. A logo is going to cover just that font and the design elements of that logo. So what you end up getting into, and this is the factual inquiry, is the word mark by itself protectable? If it's highly descriptive or something like that, but you have a logo, sometimes the logo is protectable, where the word mark, it's going to be harder to obtain protection.
Okay.
You can do both. And so, like, if you look at a company like Starbucks or Nike, they've got like a bunch of trademarks
Right.
because they layer them on top of each other. So if you're going after somebody, you got sort of more ammo to do so.
Okay.
So depending on what your budget, I don't say, well, you just need to register one mark. I would say, if you can afford it, to try to register both.
Okay. Now, in my case, the business name is actually part of the design mark. So does that cover me on the word mark side of it or not?
It does. So if you got a word mark and your word mark is in your design logo, the word mark would cover that design as well.
So
but
I could
not
do-
vice versa.
So if I were only going to do one, it would be the word mark.
Yes, but without knowing exactly what it's sort of
Okay.
like, it might, if it's hard to register the word mark, looking at the design element might be a way. Now, there's caveats
The
to
word
that.
mark is currently registered, so
Oh.
does that mean I'm covered on the design mark?
Obviously, I don't want
Without-
to give you legal
right,
advice,
sure.
but
Broadly
probably,
speaking, okay.
probably.
Okay. The second part of my question is, so the business that I'm referring to, I create designs for graphic apparel and accessories.
Yeah.
If I want to protect individual designs and phrases that I put on my merchandise,
Yeah.
do I have to register each one, or does like TM cover it?
Yeah, so the thing is that I was just dealing with this yesterday, is that when you put a design on an article of clothing, there is, I'm trying to remember the technical term for it, that may not be a trademark in and of itself.
Okay.
So there has to be an association between the mark and the consuming public. And so like just a design by itself isn't necessarily a trademark. Like from Nike, it is, because that's also their brand.
Right.
So that's something, it's sort of like if you create 10 designs, you're putting them on t-shirts, all of those are not trademarks probably, but say your company name has become known, like Nike or
Right.
whatever, if you put that on,
Working on it.
right, and then so that would be a trademark, so you would want to have that trademark. Do you sort of see the distinct?
I do. So my design mark does go on every article of clothing or
Yeah.
merchandise that I sell.
Yeah.
It's kind of.
Yeah,
So does that keep someone from copying my design
it should.
legally? Okay.
Yeah, I mean, it definitely, that's why you get that trademark protection. But if you are just putting, you say you created, I don't know what it would be, some type of design you put on a t-shirt, that doesn't mean you can immediately just trademark it.
Okay.
That would be more copyright protection.
Right.
Yeah, I think so. There's some elements of copyright having to do with fashion that I don't know off the top of my head.
Okay. Well, I know there's a
Sorry.
website I use that pertains specifically to trademarked designs
Yeah.
and or phrases
Yeah.
on clothing.
Yeah.
So I consult that a lot.
Okay.
But, I understand that, in that minute that I'm looking on that website,
Yeah.
something could be changing.
Yeah,
That,
and-
unless I'm constantly monitoring it
And that's something that, for instance, we would want to talk about.
one-on-one.
Yeah, because I don't know the answer to everything just off the top of my head.
You don't?
I wish I did. Some
Okay.
people do. I don't like to shoot from the hip.
Sure.
And so, that's something I'd want to refer to and say, oh yeah, there's some validity to that, or no, they, are a little bit off the mark, or
Okay.
something like that.
Thank you.
Yeah,
Thank you guys.
sure.
I'm so glad you're here to answer that.
Somebody else?
I have a question, Mr. Kevin. I am a business owner, and 3 years ago we opened a salon. We opened a business, was a restaurant. And last year we closed it. My question is, landlord can't pursue me for unpaid rent.
Can they pursue you for? All depends on what the contract says. But oftentimes when it's a commercial lease,
Yes, it's commercial
yeah.
lease and also it's a limited liability corporation. So
yeah.
in my case, still landlord can sue me because still I have a limited liability business corporation. My question is, still they can do?
Can sue you?
Sue
Personally?
my personal.
Depends if you sign a personal guarantee. If you sign a personal guarantee on there, they can come after you individually.
No.
And it would all depend on the extent of those damages they could go after based on what the contract says. And with, commercially, they're starting to put more reasonableness into the commercial contracts, but they're not protected by any particular Virginia statute or any type of statute that would limit damages. They can come after essentially whatever the contract says.
Even you are as a corporation, limited liability corporation, still they can.
They just come after you, yeah. Your corporation or your LLC, yeah. Yep.
Thank you.
Do either of you have experience with B corporations? And if so, can you talk about what your opinions, the advantages, or the benefit corporations?
I think my look kind of gave it away. I don't know. Do you have any? I don't.
Yeah, it's something that I think that things like that, newer type of legal entities and things like that, there's a couple of ways to approach it, because I deal with these types of things a lot from the intellectual property standpoint. Is you can go probably to a firm in Northern Virginia or DC that is going to have experience with that, and there's going to be advantages and disadvantages to doing that. You're probably going to pay significantly more for that. You're also maybe not going to be their highest priority, but they might have expertise in it. So I deal a lot with that. So say somebody comes to me and say, well, you know what, I've got this pharmaceutical compound I want to patent. So, we probably ought to go find a PhD scientist with a big firm in DC to handle that. And you're going to pay a lot for that, but you're not going to be their top priority. I think that with Kevin and I being, there's ethical requirements in Virginia for whether you undertake a matter or not. I think that something like researching about a B corporation and the appropriateness for your business is well within the scope of our reasonable expertise, that we can become knowledgeable on that subject. And we're also going to put a lot of effort into that on your behalf,
Absolutely.
Being a local counsel. Another option is that we are ethically, it's permitted for us to create, it's not a partnership, but we can go to someone. So say I knew someone in DC, this happens a lot in the intellectual property sphere for me, is someone has the expertise, say it has to do with like patenting an app. And I'll say, you know what, I'm going to work with you. I'm not going to charge you extra, but I'm going to go refer to this other attorney to help me with that. That's a good option as well, is that an attorney locally can oftentimes marshal resources on your behalf that you may not be able to do to the same extent. So I would feel comfortable saying, hey, you know what, I can help you with a B corporation. And if I can't, I'm simply going to help you find an attorney that can, and just give that work to them.
Yeah, there's not I haven't dealt with really any, and not only that, but it's one of those things where business law is organizationally, as far as foundation, the foundation of an organization, it's different. It's going to change. It changes all the time. In fact, there's a new thing out there. Several states are starting to do it. I think there's only about 14 states that currently permit it. It's called a series LLC, where you can basically set up your main LLC and then have all these other LLCs. It's still your main LLC, but they're still kind of separate because you can do different. It's something that it's just a matter of time before I think Virginia goes into it. But the problem is that these different states will have different rules, so there's really no uniformity of different of a uniform set of rules for these different for this series LLC. I don't know enough about the B Corp or the to really give you a good valid answer, but it's like Ben said, it's same thing with contract law, that we deal with a lot of different contracts. We can't say that, when someone comes in and say, hey, I need an IT agreement. Well, I've never done one quite like that before, but we'll research it, we'll figure it out, and we'll, do our due diligence and make sure we set it up right for you too. So we don't know everything. At least I don't. Do you?
Nope.
But it gives us the ability to go in, especially when we deal with businesses. There's a lot of things that we're hit with all the time. We're like, that's a good question. Let me check into that for you, and I'll get back with you. So.
Other questions?
I had one. So copyright, if I'm not mistaken, has to do with artistic expression usually, right?
Generally, yeah.
Okay. And then when say using a name, so say you get like, and it's like a movie character or something, so that's very well known. Like we'll use Stallone, like get Rambo security or something like that.
Yeah.
Where does that, like, once, if say it blows up, then when it ends up happening, using that person's and the character's name, just that general name within your company.
I would be careful about that. If you, especially something that is owned, the likeness of something like a creative character or somebody, a famous character or something like that.
Yeah.
That might not be totally above board. I would need to look into instances of that because I've never dealt with that specific situation, but I know that obviously, just kind of a gut feeling is that's, if somebody else owns intellectual property in a character, you have to tread lightly. But, think about like the name Rambo. I mean, there's going to be other instances of Rambo out there. What if your name is Rambo or something like that, right? They can't prevent that. But if, maybe if you had like a guy with a headband and a machine gun in your logo, then maybe you're getting closer to something that someone would object on.
That's exactly like what I was getting to, is like avoiding the artistic expression by using something completely different.
Yeah.
But then you have like, I think the guy who made the movie is like made Rambo is over an apple, which is a Rambo apple or something like that.
Mm.
So that's kind of where I'm getting at.
Yeah.
Is if you use the name, but then you veer off from that and use something completely different and make it your own, and so you don't. That would be.
It would probably be more likely
much more safe.
to, and you also have to look at the likelihood of somebody pursuing you about it too. I mean, for instance, a large company is probably more likely to enforce their IP. For instance, a company like Sony has a big team of lawyers with a big firm in DC that their sole job is to say, this seems too similar to our name, and that's not fun to have to deal with.
Yeah,
so
expensive too.
Yeah, and thinking about that ahead of time to the extent that you can is worthwhile, and then it ends up being a business decision whether you want to move forward.
Especially with somebody so big
risk
that you could be running into.
Yeah. But I mean, I'm not the one to say no to it. I think I try to put that back in the court of the business owner to make that decision, whether they can stomach that risk. Unless it's something that's illegal or something like that, which that doesn't sound illegal to me.
Any other questions?
I've got one more about patents, actually.
Sure.
So if you're putting together everything you want to apply for a patent, would you advise, is it okay or is it a good idea for an individual to go ahead and apply for a provisional patent
Mm-hmm.
while you're in the process of working with an attorney?
Yeah, I definitely do provisional patent applications. I definitely recommend, even if you draft it yourself, running it by an attorney, because a lot of the times provisional patent applications do not. So a provisional patent application is something that you file that gets sort of, it's a marker in the sand. and you ultimately want to, it doesn't become a patent. You have to file a non-provisional patent application, and that's what can become, it will be examined by the patent office, and it can become a patent. The provisional patent application sounds really easy, it's low cost, but the problem is you have to adequately disclose your invention in that provisional patent application for it to have any value when you claim benefit of it in the non-provisional. So the thing that ends up happening a lot is if somebody drafts it themselves, they don't have the knowledge about the patent system to understand whether enough about the invention has been disclosed in the provisional, and so you can lose some rights to that. But there's sort of a balancing act, like I've been saying all along, is if your budget is, lower, then writing it yourself and just having an attorney do some sort of review, like last minute review, is still, worthwhile doing.
Cynthia, Kevin, you mentioned earlier on that most businesses fail in the first 3 to 5 years. What are 3 points that, from your experience, that cause that?
It's a good question. I would say 1, making sure that, and it's probably the biggest one, and I've had to shut down and reopen my business 2 times. I'm on my 3rd time starting up my business, military related, odds and stuff like that. And I've gotten up fastest this last time by having a proper network of people in place that I could quickly reference in order to kind of accelerate my growth and accelerate the knowledge issues that I learned based on the first 2 times. So I would say for 1, making sure you're surrounding yourself with the appropriate network of people to get you past sticking points that are invariably going to come up. 2, I would say making sure you have the appropriate necessary contracts in place that way if something happens, it's not going to shut you down. You get sued, you're not going to get shut down. And I had a good 3rd one too. What was the 3rd one? Making sure that you don't overplan. I know that sounds kind of counterintuitive, but I think one of the things is nothing is ever going to be perfect with going out and starting up a business. And a lot of people oftentimes look to get to that perfect point before they go out there and inject their services or their products into the economy. So I would say, get something going, make sure you get yourself surrounded with people. That way when the issues do come up, because they will come up, you can say, hey, I ran into this issue. Because if you wait too long to get out there, you're not going to be making the money. The whole point of you going out on business is to be able to, to service not only the economy, but whether it's another business, whether it's another individual, getting out there and making money, because it's going to be that capital, that cash flow that comes in to where you're going to be able to grow your business to do well, and to get the other things that you need to do in place to get yourself past that point and then grow again. Because it's just no day in business is ever the same. It changes every day. It changes week to week. Your focus, you have competing priorities all the time, and just be mindful of your time. That's probably maybe a 4th one if I had to do a 4th one.
This question's for you, Ben. So with trademark protection, in drafting a business plan, you have to describe your products. So I'm working on a brew pub, and so we have names for especially our beers. Is there a way to protect those names when I'm presenting them to a bank or potential investors or the property owner? If they require that document, is there a way to protect that prior to putting them into the document, or should it just not include it, give a more general description?
Yeah, I mean, that's a great question. You can, from the standpoint of just like a pure trademark answer, you can file what's called an intent to use trademark application, which means it doesn't, so to obtain a registered trademark, it has to be in use in commerce. But you can file these intent to use applications, and that's sort of what that's intended for. Now, that assumes that you have the budget to file multiple or trademark applications, which I don't ever assume that. Another way you could potentially protect it, you're right, is omitting the names. If you think that someone's gonna be like, oh, that's a great name, I'm gonna go ahead and use that. You can probably, I can't imagine someone would be required to know the brand name of your beverage that would affect lending or whatever. A third way potentially would be a confidentiality agreement, which I would say when you're in negotiations with potential business partners, I would really try to use those, because that's also going to let you understand from my perspective, legitimacy isn't the right word, but if someone's not willing to enter into a mutual confidentiality agreement, I would be raising an eyebrow, because they're presumably going to have stuff that they're going to want to share with you that they don't want you going and sharing with the general public, and vice versa. So that shouldn't, as long as it's a mutual agreement, then they shouldn't have any problem with that, and that would preclude them from utilizing that information you've shared with them outside of the purposes of the transaction. Yes, sir.
Kevin and Ben, thank you so much. This has been wonderful. Don't you agree? Very much. So Ben and Kevin are both in Winchester. Please look them up. If it's a month from now and you can't find their information or you need them, reach out to me. I'm happy to share that information with you. As you go, I wish you safe travels. Please don't forget about our upcoming seminars, our evaluation form, and if you didn't sign in, please sign in or do a registration form. It does help us continue to get funding to help other small business owners and to continue our services. We thank you so much for coming out, and I wish you a wonderful weekend.
I want to give a shout out to Christine and the SBDC. I don't know if all of you work with them already, but they're instrumental, I think, in the success of small businesses in this community. They, I believe, offer predominantly free services, and I've never been disappointed with how I've interacted with them. And I couldn't make it as a business here without Christine and SBDC, so thank you, Christine.